It's a showdown of money versus principle at the Supreme Court. The justices have been hearing arguments over an $8 billion bankruptcy deal for Purdue Pharma, the pharmaceutical company behind the highly addictive painkiller OxyContin. Now at stake is whether or not the court will approve the bankruptcy deal, which would allot the billions for the states heavily impacted by the opioid epidemic. But it would shield members of the Sackler family who own Purdue from further legal action against them, something many families of those victims do not support. Well, joining me now to discuss is Cheryl Jouer, who lost two sons, Corey and Sean, to opioid addiction a decade apart. She testified against the Sackler family when the settlement was originally reached, and she's also the founder of Team Sharing, Inc., a national organization of parents who've lost kids to substance use disorder. They raise awareness and provide support to other families who've lost loved ones to the disease. And to break down that Supreme Court hearing and the subsequent hearings, we are also joined by Robert Barnes, Supreme Court reporter with the Washington Post. Thank you so much, both of you, for being with me.
Thank you
for having us.
So, Robert, I'd love for you to catch us up to where we are. We know this has been a lengthy legal process, one that's can be very complicated for folks who don't know legalese or in the legal profession. So where are we in terms of the argument that the Supreme Court heard this week?
Well, the court heard oral argument over this plan. As you mentioned, this is a big plan that's been worked out over years. The lower courts were a little split on it. Excuse me. But the Court of Appeals for the Second Circuit said that it could go forward. The legal question is whether the bankruptcy code allows this kind of settlement in which, as you say, billions of dollars would go to states and individuals for use in fighting opioid addiction, but it would shield the Sacklers from any further lawsuits. The Sacklers are not part of this bankruptcy proceeding, and that's part of the issue for the court. But the lower courts found that there is part of the bankruptcy court code that says courts can approve such deals if they are appropriate to bring about a settlement in a complicated case. So there is a legal question on the one hand, whether this is actually allowed by the bankruptcy code, and then sort of another question about, is this as good a deal as anyone's going to be able to get from the Sacklers and from Purdue?
So correct me if I'm wrong, Robert, this would protect the Sacklers to some degree from other suits. Once this bankruptcy, the settlement money is being dispersed, it would protect them from other suits, correct?
That's right. Those who are in favor of the deal say that the $6 billion that the Sackler family members are going to contribute to this fund is what makes it work, but that the trade-off for that is that they would be immune from further lawsuits.
Yeah, and some families say that that price is too high. Cheryl, I want to bring you in because, as we mentioned in our introduction, you know, this is very personal for you, losing two sons. So talk to me a little bit about that. You've been on the show before. Welcome back. And what you think about this latest step in this legal fight.
Well, first of all, I've sat on the Unsecured Creditors Committee. So I've watched this whole thing unfold for the past 4 years. When I first joined the Unsecured Creditors Committee, my thought process was, great, I'm going to help bring the Sacklers down because back in 2018, when Attorney General Maura Healey filed a complaint against the Sacklers, and I learned about Purdue and OxyContin and the Sackler family, I made it my mission to bring them down. We worked for 2 years to come up with a plan on the creditors committee with 50 attorney generals and the debtors and creditors and hospitals. And we worked really, really, really hard. And I learned that most likely they were not going to go to jail. And so the best plan that we came up with, and even though it started at $2 billion, we ended at $6 billion. We decided that that was probably going to be the best plan out there or offered. My thought process on this also is that there's no amount of money that's going to bring my kids back or any of these children's back, but we need to start saving lives now. We need to take that money and we need to start saving lives.
Cheryl, tell me a little bit about your boys and the impact this has had on your family.
Well, I had 3 sons, and I lost Corey in 2011. And back then I didn't know anything about OxyContin or his addiction. And he tried to explain it to me, and I didn't know anything about it. I just thought it was a choice. And I've learned so much since. Sean was addicted as well. They used to do drugs together. And then Sean got into recovery, but he never dealt with the loss of his brother. And so 10 years later, he succumbed to addiction.
Yeah. So, Robert, when we're talking about this case and the families, from I understand, and please correct me if I'm wrong, the majority of families were in favor of this bankruptcy settlement. I think the number is 97%, but there are families who don't think this is justice.
Yeah, that's right. The overwhelming majority of those who voted for this plan. The federal government says that there are others who didn't vote, and so you can't really say what they feel about the plan. But the government says that the law simply doesn't allow this, that the bankruptcy code can't shield a family that doesn't actually put themselves up for bankruptcy, and that the Sacklers, didn't do that. They, in most bankruptcy cases, those who are involved put everything on the table, as one of the justices said, and that hasn't happened in this case. But as I say, it was very much during the oral argument a case between sort of practicality and the law. And you could see that a number of the justices were torn about this and whether there really was a better deal available out there if this one was turned down, or whether, it would just turn into something where each creditor would try to get some sort of award against Purdue or the Sacklers, and that would sort of take all of the money and there would be none for all of the others out there. I mean, the actual estimates of the charges against them, the claims against them, is $40 trillion. And so obviously there is no way to recover all of that money.
Yeah, we actually have some data chart here that sort of highlights the opioid-related overdose deaths just in Massachusetts. And if this settlement goes through, Massachusetts getting some money to deal with that, showing that there has been a steady increase as we go from 2000 to 2022. You can see the numbers right there. The Sacklers implicated in this spike of opioid deaths. And so, Cheryl, I'm thoughtful about this is some money. It certainly isn't all the money when we're talking about $42 trillion. Does this feel like justice to you, to your boys, and to the families in Massachusetts that you know?
If we can take that $110 million and put it to good use in Massachusetts, yes, it would be that my children did not die in vain. If we let this money go, there's no hope out there. There's no hope. The Sacklers, there'd be a mad race to the courthouse to see who gets what first. In this plan, 50 attorney generals sat there and there was a formula on how much each state was going to get. And it was by overdose deaths in each state. So let's just say California is going to get $357 million and Massachusetts 110. If this doesn't happen, Massachusetts might get $1 and California nothing. I mean, so there's a plan in place, and it makes sense. I sat on the committee, I know, And it's been 4 years. And you know how many people have died in these past 4 years? Hundreds of thousands while we're bickering over money.
Yeah.
And I'm just going to say, I'm a woman of faith. And so they're going to have to one day stand in front of an ultimate judge, the ultimate judge. And they're going to have to answer to him. And so if they don't get their due diligence here on earth, I'm counting on the other side.
Yeah. Robert, one of the other arguments that were presented in the court as well, it has to be with this definition of bankruptcy and bankruptcy protection. And if it's stretched here, you mentioned a little bit about that, but also if this will open up the door to other companies perhaps not settling or not going into bankruptcy protection in the future because of what could be the outcome of this case. I wonder if you could talk to us a little bit about that.
Yeah, there was talk about that at oral arguments. It's a little unclear how it would play out, and it's always difficult in these kind of cases to say how it would affect other cases until we know what the Supreme Court is going to do. But, there are settlements, for instance, against Boy Scouts for abuse there. There were settlements against the Catholic Church that involved some of these kinds of trade-offs. I think both of those could be impacted by the ruling in this case if the court goes the other way. Lawyers in both of those cases file briefs with the Supreme Court pointing that out. And so you're right that it is about this case, but it also could be about some of the other huge and sort of complicated, complex settlements that have gone before it.
And I understand the Sackler family actually took a large sum of money. I think the number was $11 billion out of the company, or $1 million out of the company before this settlement was put in place. And I know that was an issue for some of the families.
And for the justices, too, I would say. They asked about that. The Sacklers say that half of that money went for taxes. But I don't think anyone would dispute that the Sacklers haven't put, as I said earlier, everything on the table. So that was a concern for the justices. As I say, it's a very complicated case, and your guest has made the case far better than I could about why it is so troubling and complex and complicated. But she certainly speaks well for those unsecured creditors and even for Purdue Pharma in saying why this is the best deal that they think they can get.
Cheryl, talk to me about what it was like, and you touched upon this a little bit, but being in that room for 4 years fighting for this deal. What don't folks on the outside know what happened there?
It was actually 2 years until the plan was confirmed, but with appeals, it's been 4. So yeah. I've had to sit through hearings in front of the Sacklers. I've had to listen to their testimonies. Richard Sackler on Zoom, almost face to face, was probably the hardest thing I've ever done in my life because I had to stay quiet. And that was really, really difficult. But I saw there was so much arguing and negotiations and just so much going on inside that nobody knew. And the sad thing was, when I first got on the committee, I was told my fiduciary duty was to be silent. I couldn't speak to the press, or I couldn't speak to my community of supporters. And I just had to say, you've got to trust me in this. And so it was hard not to share all of that happened. But at the end of the day, through the Second Circuit, through all that's gone on, I still believe that this was the best plan that they could come up with. And it took probably a year to get it from from 4 to 6, $1 billion. We don't have that time anymore. We really don't have that time. We're losing kids. As you said, there's an uptick. We're losing them every day. I lost my son, Sean, while I sat on the unsecured creditors committee in 2021.
Yeah.
So they all saw it. Purdue saw it. The attorneys saw it. The creditors committee saw it. They all knew, and it made me want to fight even harder.
Absolutely. Yeah.
And justice for the Sacklers, putting them in jail is not going to help anybody.
Well, we're going to have to, it's such a complicated case, but we're going to have to leave the conversation there. Cheryl Duerr and Robert Barnes, thank you so much for your time.
Thanks for having me.
Thank you.